Ready, start. The court proceeded to state further, double inverted comma, in the notice, demand has to be made for the double inverted comma said amount double inverted comma close, that is the check amount. If no such demand is made, the notice no doubt would fall short of its legal requirement. Where in addition to the double inverted comma said amount double inverted comma close, there is also a claim by way of interest, cost, etc. Whether the notice is bad would depend on the language of the notice. If in a notice while giving the breakup of the claim, the check amount, interest, damages, etc. are separately specified, other such claims for interest, cost, etc. would be superfluous and these additional claims would be severable and will not invalidate the notice. The court observed that the demand in the notice has to be made for the said amount, which would be the single inverted comma check amount single inverted comma close. If no such demand is made, the notice would fall short of its legal requirement. In the facts of that case, however, the court held that since the check amount in the notice was correctly stated merely because the respondent claimed, in addition to the check amount, the incidental charges and notice charges which were severable, notice could not be branded as bad in law. It was further observed that, however, if in the notice an ambiguous demand is made without specifying the due amount under the dishonored check, the notice would fail to meet the legal requirement. In other words, what was pinpointed was that the words single inverted comma said amount single inverted comma close in proviso within bracket B has to be same amount of the check which is dishonored. The object of the notice under proviso within bracket B of section 138 of the Act was explained by this court in Central Bank of India versus Sections Forms and others, observing that the purpose of the notice is to give a chance to the drawer of the check to rectify his omission. Once the defaulter makes payment of the amount covered by the check as mentioned in the notice within stipulated 15 days, he would stand absolved from his liability. No doubt all penal statutes are to be construed strictly, that is to say, the court must see that the thing charged as an offence is within the plain meaning of the words used and must not strain the words on any notion that there has been a slip, that there has been a casus omissus, that the thing is so clearly within the mischief that it must have been intended to be included if thought of. On the other hand, the person charged has a right to say that the thing charged, although within the words, is not within the spirit of the enactment. The distinction between a strict construction and a more free one has, no doubt, in modern times almost disappeared, and the question now is what is the true construction of the statute? I should say that in a criminal statute, you must be quite sure that the offense charged is within the letter of the law.